Court does call the case of Cross Street Apartments versus Hannah Schumacher.
Good morning, Your Honor. Norman Whitty appearing on behalf of the plaintiff, Cross Street.
Welcome back to Trial Truth, where every courtroom exchange has the potential to completely change someone's future. Today's docket might look like a routine landlord-tenant calendar at first glance, but don't let that fool you. These cases often reveal some of the most relatable legal disputes ordinary people face every single day. Behind every unpaid rent claim is a story, and sometimes that story is far more complicated than simply, someone didn't pay. One tenant claims she's withholding thousands of dollars in rent because the landlord allegedly failed to provide a basic service promised in the lease. Another resident insists wildlife has made his home nearly unlivable, claiming an animal is crawling underneath his trailer night after night. Several tenants say they're trying to catch up financially after unexpected hardships, while others admit their own mistakes with surprising honesty. Throughout it all, Judge Simpson has to separate legitimate legal defenses from excuses, all while ensuring both landlords and tenants receive a fair hearing under Michigan law. One thing you'll notice immediately is that this judge doesn't rush to conclusions. Instead, he repeatedly asks one important question: how are you intending on getting that paid? That simple question often determines where the case goes next. Sometimes the answer leads toward dismissal. Other times it reveals legal issues that require additional evidence before any ruling can be made.
And Ms. Schumacher?
Um, Hannah Schumacher.
All right, very good. Okay, where are we on this case?
Your Honor, this is a non-payment of rent case. We did not ask for a money judgment. Currently, rent is owed in the amount of $2,425 through the end of October. Court costs are $164.40. Total amount to retain, $2,589.40.
Right. Ms. Schumacher, how are you intending on getting that paid?
Your Honor, I have my full rent amount placed in escrow until the landlord can provide, uphold their lease obligation of sanitary and accessible trash as per the lease.
So when you say trash, I guess I'm not clear what you're referring to, ma'am.
Yeah, so section 1.7 of my lease states that the landlord shall furnish the tenant the following utilities: water and trash. I do not have a sanitary and accessible trash bin, which is why I have placed my rent into escrow.
So there are no trash bins?
No, Your Honor.
Okay. All right. What I'll need you to do, ma'am, is I'll need you to file a written answer with the court within the next, when's my next day? October 31st. You'll need to file a written answer to the court by October 30th, 2025. You need to provide a copy of that written answer to counsel. You need also to provide information as to where the rent is being held in escrow. I will reserve the issue of escrow for payment to the court for determination at the next proceeding. I'll adjourn this matter out to October 31st, 2025 at 12 noon. And ma'am, that's an in-person proceeding, so you'll need to be down at the courthouse.
Thank you, Your Honor.
All right, thank you.
Your Honor, I'm happy to give her my email address so she can email me that answer if she'd prefer.
Will that work better for you, ma'am?
Yes. Got it. Thank you so much.
Thank you.
All right, thank you.
This opening case demonstrates an important legal distinction that many renters misunderstand. Hannah didn't simply refuse to pay rent because she was unhappy. Instead, she argues that the landlord failed to fulfill a specific lease obligation by not providing sanitary and accessible trash service, something she claims is expressly promised in the lease agreement. Notice what Judge Simpson doesn't do. He doesn't immediately side with either party. He also doesn't instantly accept her claim that placing rent into escrow automatically protects her. Instead, he requires documentation. That's exactly how civil courts operate. Assertions alone aren't enough. You need evidence. The judge orders her to file a written answer explaining her legal defense and to provide proof showing exactly where the escrow funds are being held. That last part is crucial. If a tenant claims the rent has been preserved in escrow, the court wants verification that the money actually exists and hasn't simply been spent elsewhere. This hearing also shows why professionalism matters. Rather than turning the proceeding into an argument, both attorneys cooperate, even exchanging email information to simplify filing requirements. Those small moments of cooperation often save everyone time and unnecessary litigation.
Court does call the case of Linden Park Apartments versus Keith Young.
Good morning, Your Honor. Norman Whitty appearing on behalf of the plaintiff.
Keith Young, they're not here. Did you pay for second service? I don't see it on
We
here.
didn't, and we have service by attachment, so we'll have to adjourn.
All right. Adjourn the matter to October 31st, 2025 at 12 noon.
Thank you, Your Honor. Have a good day.
All right. You do the same, sir.
Thanks.
Pleasant Lake Park versus Christopher Janowak.
Good morning, Your Honor. David Morris, P83922 on behalf of the plaintiff.
Christopher Janowak.
Hey, hello, Judge. My video doesn't work.
Okay. All right. We've got some echo coming from whatever device you're on, but we'll make it through. It's just one of those days. Counsel, what is the plaintiff's claim?
Plaintiffs, this is a non-payment action with rent to retain of $730, including costs and fees.
730?
Correct.
All right. Sir, how are you intending on getting that paid?
So I intend on getting it paid, but this trailer I live in backs up to a lake. My trailer is like the closest trailer to the lake, and since I've been living here for about almost 3 months now, and this big badger or like beaver animal, it's crawling up under my trailer every night, like underneath my bed, and there's holes all around the skirting of my trailer, and they've already boarded up about 10 feet underneath the main stairs, and they boarded up 20 feet on the southern side, and then I'm asking him to board up another 10 feet on the western side, and he won't do it. And this animal is like, it's nesting and zooming around and biting underneath my bed, and I've been sending him text messages and stuff for like 2.5 months, and he's been lying. His maintenance man works here and lives here in the park, and the owner
All
of
right,
the park
sir. Sir, you're gonna have
Right.
to file a written answer with the court. You're gonna need to do that by October 30th, 2025. You need to provide a copy of that written answer to plaintiff's counsel regarding
Yes,
what
Judge.
your claims are. All right. I'll
Yes, Judge.
reserve the issue of escrow for the next hearing. I'll set the next hearing for October 31st, 2025 at
Yes, Judge.
12 noon. That is an in-person hearing, and you'll have to appear at the courthouse, okay?
Yes, Judge. Thank you for your time.
This next case takes an unexpected turn. Instead of arguing over missed payments, the tenant begins describing what sounds like an ongoing wildlife problem beneath his trailer. According to him, some type of large animal, possibly a badger or beaver, is crawling underneath the home night after night, creating noise and fear while he says management has ignored repeated complaints. Now, whether every detail ultimately proves accurate isn't something the judge can determine during this brief hearing. That's exactly why Judge Simpson interrupts before allowing the conversation to spiral into an unsworn factual dispute. Courts rely on organized evidence, not extended storytelling during an initial appearance. By directing the tenant to submit a written answer, the judge ensures the allegations become part of the official record. If maintenance requests, photographs, text messages, or repair records exist, those documents will matter far more than emotional descriptions during today's session. This is another example of judicial efficiency. Rather than attempting to resolve a potentially complicated habitability dispute on the spot, Judge Simpson schedules an in-person hearing where both sides can properly present evidence and where the escrow issue can be addressed under the correct legal framework.
All right, thank you.
Thank you, Judge. Bye-bye.
You said it. That was it for counsel. Evergreen Apartments versus Zelly Everett and Christopher Coyle.
Morning, Your Honor. Jillian Aiken for plaintiff.
They're both here.
They're both
Here,
here.
Your Honor.
Hi.
Okay. Okay, they're both here. Okay, they are both here. All right. What is plaintiff's claim in this case?
I have a balance including court costs of $3,237.72.
3-2. I'm sorry, counsel.
Sorry, $3,237.72.
All right. And folks, how are you intending on getting that paid?
We were both having some financial issues due to some circumstances, but we in the process and have gotten most of it, but we are about to pay it.
Okay, all right.
Yeah,
I think I understood what you said. So
my
you've
car
gotten,
recently got stolen, so we haven't been able to get to work. So it's been
But
we're taking the bus to work, to and from work. But we're
okay,
in the process of getting the rest of the money.
yes,
gotcha. Okay, so let me ask you this. How much of it do you have now?
probably we have one of the month's rent and we're trying
About
to
half
put
of the
it in.
other.
Okay, that told me nothing because I don't know what your monthly rent is. Tell me a dollar amount, how much you guys think you have?
About $2,000, a little over
2
$2,000.
grand? All right, let's do this then. Why don't you get the 2,000, get that paid to the landlord?
Okay.
Okay. And then, so you can pay that, say, by Monday?
Yeah, probably, yeah.
Yes.
Okay. Get
Yes.
that in. If you can get it in today, that'd be great, but get it in by Monday. I'll adjourn this out to October 31st, 2025 at 2 p.m. That's an in-person hearing, so
Okay.
you'll need to be down at the courthouse, all right?
Okay.
Okay, if you pay it on or before that date, you may not need to come down if you verify it with your landlord because they'll just dismiss the case out if you get everything paid.
Okay.
Okay, fair.
Zero.
Pardon?
If they get down to zero, yep, we'll
Yep,
dismiss.
they'll dismiss it. Okay, folks?
Yep. Thank you, Your Honor.
All right, thank you. You guys have a great weekend.
You
You
too.
too.
This hearing highlights something Judge Simpson has emphasized several times already. Courts appreciate honesty and realistic payment plans far more than empty promises. The tenants openly admit they've fallen behind because life threw them several unexpected setbacks. A stolen vehicle disrupted their ability to get to work, forcing them to rely on public transportation while trying to rebuild financially. Instead of making excuses or arguing with the landlord, they explain exactly where they stand and, more importantly, what they can pay right now. Notice how the judge immediately shifts the conversation from blame to solutions. Rather than dwelling on the past, he asks a practical question. How much do you have today? That's often what civil judges want to know. If a tenant can demonstrate good faith efforts by making a substantial payment, it shows responsibility and may persuade the landlord to continue working toward a resolution instead of pushing for immediate possession. Another important legal takeaway is the judge's reminder that if the balance reaches zero before the next hearing, the landlord can simply dismiss the eviction case. That means the courtroom becomes a backup plan rather than the final destination. Everyone benefits if the debt is resolved before another court appearance.
Evergreen Apartments versus is it Magam?
Jillian Engen for plaintiff.
Sir, you'll have to unmute.
Jermaine Magham.
Magam. Okay. And what is plaintiff's claim in this case?
I have a balance including court costs of $1,771.35.
All right. And sir, how do you intend on getting that paid?
I supposed to been paid it. I just been being lazy.
All right, fair enough. No, I appreciate your honesty. So when can you get it? When can you get it to them?
I can do it today.
Okay. Why don't I do that? You're gonna pay the whole amount then
Yeah.
today? Okay.
Yeah.
So I'll indicate that you're gonna pay the balance today. If you get that paid, then what will happen is they'll dismiss the case if you're down to zero. Okay.
All right.
So what I'll do then is I will adjourn it out to the 31st, 2025 at 2 p.m. You said? At 2 p.m. That's an in-person hearing, so you'll have to come down to the courthouse if you don't have it paid. But if you got it paid, then you're good.
All right. I should be good then.
All right. You just don't want to come down and see me and let me yell at you. All right. I got
Yeah.
you. All right. Okay. Have a good weekend.
You too.
Sometimes the shortest courtroom exchanges become the most memorable. When Judge Simpson asks why the rent hasn't been paid, the tenant doesn't invent a complicated story or blame someone else. Instead, he simply admits, "I've just been being lazy." That's probably not an answer most attorneys would recommend, but it instantly changes the tone of the hearing. Rather than criticizing him, Judge Simpson actually thanks him for being honest. That doesn't erase the unpaid rent or remove the legal obligation, but it demonstrates an important principle in court. Credibility matters. Judges hear countless explanations every week, and many are difficult to verify. A straightforward admission, while uncomfortable, can sometimes carry more weight than an elaborate excuse that falls apart under questioning. The judge also makes the legal consequences crystal clear. Pay the balance today, verify that the account reaches zero, and the landlord will likely dismiss the case. Fail to follow through, and the tenant will be back in court for an in-person hearing. In other words, today's promise becomes tomorrow's responsibility. The lighthearted joke about not wanting to come down and see me and let me yell at you also serves a purpose. It keeps the atmosphere respectful while reinforcing that deadlines are serious. Humor can ease tension, but it never replaces accountability. That's a balance Judge Simpson manages exceptionally well throughout these proceedings.
All right. Evergreen Apartments versus Keontae Lowry.
Jillian Engen for plaintiff.
Keontae Lowry.
All right. And what is the claim in this case?
I have a balance including court costs of $2,815.92.
All right. And ma'am, how are you intending on getting that paid?
So the situation is I've honestly been trying to turn in my keys because I've had so many issues with it. I don't stay there anymore. And the last time I went to go turn in my keys, they told me to wait because they had to talk to, I guess, Sydney and the director of Evergreen. So I'm not sure what's going on. This was 2 days ago. I haven't heard anything, but I no longer stay in that apartment.
Okay, so you're vacating the premises?
Yes, I already vacated the premises a couple
Okay,
weeks
so
ago.
you'll need to, I don't know why they're not taking the keys, but you'll need to go over and turn in the keys. Okay.
I think the situation is because the account manager, she made me sign an early termination, but because of everything that's going on, the property manager told me that I shouldn't have had to sign a early termination. I should have just been able to stop my lease and turn in the keys. So that's why she said she was going to talk to the account manager and the director, but I haven't heard anything since I went to go try to give her my keys.
All right. So here's what I want you to do. I'm going to adjourn this out to the 31st, 2025 at 2 p.m. That's an in-person hearing. They're asking only for possession or payment on this case, okay? So if you're giving them possession, then you need to give them possession, but you have to turn in the keys to do that. So what I'm telling you to do is to go over and turn in the keys. Counsel will let her client know that they're to take your keys. And then hopefully this matter will be dismissed out. There may be some monies that you may owe.
Yeah, that's perfectly fine.
But hold on, you can work that out with the landlord. Okay?
Your Honor, if you want to swear Ms. Lowry in, I can just have her surrender possession now, and then she doesn't have to worry about turning in her keys.
Oh, okay. Okay, gotcha.
You might as well just do it now, and then she can bill pro.
All right, ma'am, can you raise your right hand? Other right hand. All right. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. And ma'am, you have indicated that you have voluntarily vacated the premises at 3109 Woodland Hills. Is that correct?
Yes.
All right. And you are surrendering that to the landlord?
Yes.
And you're giving up any claim for any property that may be remaining there, and they can consider that abandoned.
Yes. I mean, there's nothing there, but yes, if they find anything.
I got you. All right. Very good. All right. Then if she's done that, what do you want to do with the case? You want to just dismiss it now? Or
Yes, Your Honor, we'll submit a dismissal probably later today.
All right. Given that testimony, then this case will be dismissed. That's without prejudice, and they'll take the apartment over, okay?
Okay, thank you.
This may be the most legally significant moment in today's entire docket. Unlike the previous cases, this dispute isn't resolved because money suddenly changed hands. Instead, it ends because the core issue before the court, possession of the property, has already been addressed. The tenant explains that she has moved out and attempted to return her keys, but confusion inside the property management office prevented the process from being completed. Rather than allowing that administrative delay to keep the lawsuit alive, the plaintiff's attorney offers a practical solution: place the tenant under oath and have her formally surrender possession right there in open court. That's exactly what happens. By giving sworn testimony that she voluntarily vacated the apartment and abandoned any remaining property, the tenant creates a clear legal record. Once Judge Simpson confirms those facts, the landlord no longer needs an eviction order because possession has effectively been returned. Notice the phrase, dismissed without prejudice. That wording is important. It means this particular possession case is ending, but it does not necessarily eliminate any financial obligations that may still exist between the parties. Questions about unpaid rent, fees, or damages can still be addressed separately if necessary.
Thank you.
Yep.
Glencoe Hills versus Cherie Whitfield.
Jillian Engen for plaintiff.
Good morning. Cherie
Good morning.
Whitfield here.
Okay, there you are. Okay. All right. What is plaintiff's claim?
I have a balance including court costs of $2,204.06.
All right. And ma'am, how are you intending on getting that paid?
Going to pay it right now as soon as it's adjourned.
Okay. All right. So you're going to pay the balance today?
Correct.
All right. So I'll indicate that in the file. I will adjourn it out. And I think you probably heard me say to people that this is an in-person hearing on the 31st at 2 p.m. But if you've got everything paid, I don't need to see you.
No need, sir. Thank you.
Okay. Well, we'll miss you. Okay. All right.
Thank you.
You take care, Ms. Whitfield. Have a great weekend.
Thank you. You as well.
Today's docket proves that landlord-tenant cases are rarely just about unpaid rent. Behind every balance is a different story: financial hardship, property maintenance concerns, communication breakdowns, or confusion over lease obligations. Throughout these hearings, Judge Simpson stayed focused on one thing: applying the law fairly while giving both landlords and tenants a chance to resolve their disputes. We saw tenants raise legal defenses, admit financial struggles, promise immediate payments, and even formally surrender possession under oath. Rather than rushing to judgment, the court repeatedly emphasized evidence, documentation, and practical solutions. Whether it involved proving escrow, paying down a balance, or officially vacating a property, every case followed the same principle: facts matter more than excuses. The biggest takeaway is simple: knowing your legal rights is important, but following the proper legal process is just as important. A little preparation today can prevent a much bigger problem tomorrow. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.